Good evening. It is 7 o'clock. Do I hear a motion to conclude executive session and begin general session?
Madam Chair, I move that we close executive session and begin general session.
Thank you, Dr. Powers. Do I have a second?
Second.
Thank you, Mr. Anderson. All in favor, please say aye.
Aye.
Anyone opposed? And the motion carries. All right. I call to order the general session of the October 19th meeting. The district is in compliance with the South Carolina Freedom of Information Act by notifying the media of the date, time, and place of the meeting. The district tapes the meeting for accuracy in preparing the minutes. At this time, I yield the floor to Ms. Kathy Henson to lead us in the Pledge of Allegiance.
Please rise and join us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Do I hear a motion to approve the agenda as presented?
Madam Chair, I move that the board accept the agenda as presented.
Thank you, Dr. Powers. Do I have a second?
Second.
Thank you, Mr. Oswald. Is there any discussion? All right, all in favor, please say aye.
Aye.
Anyone opposed? And the motion carries. Board members, you have received the minutes of the September 7th, 21st, and 29th board meetings. Other than corrections that have been received and made, are there any other corrections? Hearing none, the minutes will be accepted as presented. Do I hear a motion to amend the minutes of the July 20, 2021 board meeting?
Yes, per policy BCBH that states minutes will include supporting materials where such information serves to clarify matters on which action is considered or taken, and because the approved minutes of the July 20th, 2021 board meeting reflect that Jada Garris's email to the board was included, I make a motion to amend the minutes of the July 20th, 2021 board meeting to include Jada Garris's email to the board as requested during the July 20th, 2021 meeting.
Thank you, Ms. Garris. Do I have a second?
I'll second for discussion.
Thank you, Dr. Guyton. All right. The floor is now open for discussion.
So I'll just give some background. So during the July 20th, 2021 meeting, in agenda item 9.9, I requested information from administration, and as part of that discussion, and in order to provide context to my request, I requested that the emails between the board, myself, and a staff member be included in the minutes. When the minutes were posted, I saw that the email between the board and myself was not included. So I asked to have an item placed on the agenda to amend the minutes to include my email to the board. The board's attorney was then asked to provide a legal opinion about my request to include my email to the board. The attorney's legal advice consisted of board policies about board member conduct and the relationship between the board and superintendent, but never once mentioned the policy regarding board minutes, nor was state law mentioned. And when you look at state law, it says minutes of public bodies shall include information that any member of the public body requests be included in the minutes. And our policy regarding board minutes echoes the law and even lists it as a provision. And several years back, Lexington Richland 5 board had questions about what board members could include in the minutes, so they received legal advice from their attorney, and he said that we believe the South Carolina court would likely hold that the board's minutes must include only information requested by a board member relevant to the board's business and consistent with the general purpose and content of meeting minutes, but not documents irrelevant. So, and it said such information may include documents or prepared statements that are relevant to the board's business, which a board member requests be attached to the minutes. So I know the attorney has provided a redacted version of the email to the board. I would just ask the board to carefully consider redacting information from a public document that was provided to a member of the public through the Freedom of Information Act with no redactions, meaning there is no legal basis for information to be removed from this document. And other redacted parts of this document include information that is already included verbatim in the same minutes.
Thank you, Ms. Garris. Is there any other discussion or comment?
Yeah, as I've kind of looked at this process, and to me, this is more a question about process than it is about the actual email correspondence. I do have questions that quite frankly, in my mind, I don't have answers for. While I read the same law that says, board members can request that any item be added to the minutes, it makes me wonder, what's identified as reasonable versus what's not reasonable. And at the same time, I have questions, for example, myself and I believe another board member were not present for that meeting. So can we vote, for example, on approving those minutes for something that we were not a part of? That would be a question. Certainly, Ms. Garris, I appreciate the viewpoint from the attorney at Lexington Richland 5. I would have the same opinion, I think, of South Carolina School Board Association's attorney and potentially the Office of the Attorney General, because to me, this is a bigger question than just a solitary email. This is more of a question of process, and this is something we'll kind of hit on a little bit later, not to tell our hand a little bit, but as a part of the ad hoc committee, this has kind of been some of the questions that we have, more from a process perspective than the actual result. So I personally would move that we table this until we get some additional opinion for how we can proceed. I think that'll allow us some time to get an opinion from the Attorney General or the Office of the Attorney General. It'll allow us to get some time from the South Carolina School Board Association. So we've got future clarity on what we can have added to minutes in the future. I think that's a more reasonable way to operate.
Thank you, Dr. Guyton. Is there a second to the motion to table this?
I second.
Thank you, Ms. Garris. And I agree with that because, as Ms. Garris stated, there is a very clear statement in FOIA law about minutes, but there are other laws and policies at play, and without some clearer guidance, I think it's murky for how to proceed on this. So I appreciate the suggestion that we slow down a little bit and get some more clear advice on this. So all in favor of tabling this?
One more comment, and I would add, again, from an operational perspective, I think the minutes should reflect what was discussed and the material that was presented. If we get into the business of attaching multiple emails to minutes, I'm not sure what that adds. It should be based upon the content of what was discussed and the material that was presented.
Thank you, Dr. Powers. All right, all in favor of tabling this, please say aye.
Aye.
Anyone opposed to tabling it? All right, this item has been tabled. Thank you very much.